Know this, do not give up on your legal status. Many people fail to respond to RFE or file an application before the deadline. This is why we offer a strategy session for 15 minutes at no cost to you. Not everyone qualifies. First, you need to speak with our CARES team. We receive many requests, so we recommend you answer a few questions on our website, greencardguys.com. Our mission is to help people live and work in America legally. Go ahead and subscribe below and follow and share. Talk to you soon. Okay, today's topic is about what's going on in Florida. It's, for lack of a better phrase, a shit show. So, excuse my French. It's very unfortunate that one of the states in America has done something like this. Other states like Texas, Arizona have done something smaller extent, I guess you can say, less impactful. But this is a serious concern. Okay, folks. So, of course, I don't want to, there's plenty of attorneys already talked about this, what's going on in Florida. But if you are an employer, you really have to make sure you know what you're doing. You need to speak with an employment attorney and also immigration attorney that have understand these bills, these laws. It's not a bill anymore. A bill is a proposal. Now it's a law that's taking effect on July 1st of this year. So that's why we're talking about now. Been wanting to talk about this for a couple of weeks, but just got a little behind. But yeah, today's June 19th. Hope everyone had a great Father's Day and also happy Juneteenth to everyone. Let's see here. Finally, President Joe Biden was able to formalize Juneteenth as a federal holiday. And unfortunately, not every company recognizes it to give it a holiday. My wife's company didn't. It's very unfortunate and surprising, actually. But anyway, the thing is, especially for employers, okay, there's always this talk with E-Verify. It's basically an electronic online way that companies are required to verify a person's work authorization. Is it going to be a good system? Who knows? Government systems tend to be a little bit wonky, but when it comes to E-Verify currently through the ICE SEVA system for like OPT, for example, I've always been told it's inaccurate. It works. So, but who knows how accurate it will be on a state level for Florida. So even if whether it's accurate system or verified or not, I don't know how they're going to do that because it's going to be quite interesting to see if there's a way to connect the Florida system to the U.S. government. So not sure exactly how that works, but for those who own a company, maybe you're entrepreneur, and of course, whether you have status or not, that's not the point. It's really about companies having to verify the work authorization for the workers. Okay, so based on the text of the law that I found so far, and I'll have another video and goes in more detailed. I can share my screen and all that. But as far as I read, if you have a company that's you have over 25 employees, this is when you need to verify your employees' work authorization. Okay. Of course, I'm here to answer any questions in the meantime, but I do want to share an alert, basically a red alert that you gotta be complying with this law. Okay, whether we like it or not. And it states on they call it the Florida Department of Economic Opportunity. Oh, is it really? Well, apparently that agency will be responsible to enforce the E-Verify requirement. And there's pretty harsh financial penalty for employers who fail to use the E-Verify. Okay, they'll be fined $1,000 a day. And for workers, it'll be a felony to use a false ID to get a job. How will they know if a company is not complying with this law? Okay, number one, for me, I think it de-incentivize, is that a word? De-incentivize a company from even putting a person on payroll, okay, on legitimate payroll, which of course you need to follow the law. But because when you put someone on legitimate payroll, I can speak because I'm an employer myself, is at least with Texas, I have to update, our HR has to update the state of Texas every time someone new is hired, right? Or if any time someone is no longer on the team, no longer employee, we have to reduce that number. Okay. So that's one way they can know. So for anyone who's always saying, who thinks and has a mindset like, how will they know? Just assume the Florida government will know. Okay. You definitely don't want to be in a situation where you're having to pay penalties. So are there ways to think outside the box? Probably. There's probably other ways to get around it, but legally, of course, while still complying with all the laws and telling the government how many people you have on staff, things like that. There's probably other ways around it, but you need to contact an employment lawyer in Florida so you get more accurate information. Okay, but the key number here is if you have 25 or more employees, you do have to comply with the E-Verify starting July 1st. Okay, happy to answer any questions, whether it's on YouTube, Facebook, Instagram, or TikTok. How y'all doing? Let me know in the comments how you're doing, because I've been out for a week just trying to, get some R&R, relax a little bit. Hopefully you guys had a great Father's Day and happy Juneteenth for y'all. But yeah, this law in Florida is a disaster. Vice Chief MD, you asked, you're a U.S. citizen, who can you petition for? Okay, most common one, of course, is a spouse who's whether they're here in the U.S. as enter with a visa, or they did not enter a visa. Because if they did not enter a visa, there are some exceptions to get the resident status here in America, but the default is having to get the visa abroad, and there is a waiver process for that. Okay, so a U.S. citizen spouse also counts as a qualifying relative for the waiver. Not everyone's eligible for waiver. A U.S. citizen can also sponsor a child under 21. Okay. Now, the key thing here, even though immigration law allows for under 21 child to be sponsored, and you might wonder, well, people might wonder, well, how are you a U.S. citizen but not your child? Maybe, maybe your child's born outside America and you weren't a U.S. citizen yet, and you've gone through a naturalization process, and now you want to sponsor your child into America, or you are maybe you're married to someone who doesn't have status or has status, and that person already had a child before you got married. So even though USCIS, U.S. Immigration Agency, will allow you to file a petition for your stepchild who is under 21, the marriage with that parent, with the other parent, has to have occurred before 18 years old. Okay, so it's a key fact that's a key requirement that most people might forget. Okay, also, let's see here. You can also sponsor your parent. Okay, so if you're a U.S. citizen, right, that's what you're saying, Vice Chief MD or DMD. If you're the U.S. citizen and you have a parent, whether they're here in the U.S. or they're abroad, you can also file a petition I-130 for them. Okay. Now, some people might wonder, well, I have a company. Well, sorry, before I get to that other option, let's say about your parent. And some people wonder, well, can I start the petition process here in the U.S. and they're abroad, but let's say they're already in the U.S. Okay, the petition's already filed, but they have come to the U.S. on a visitor visa. Let me give a different scenario. All this information, by the way, you need to contact an immigration attorney so you can have a one-on-one, because this right here is just very quick and we don't know your situation, right? So we want to verify it so that you can depend on the information accurately. We're here to give quick information so you can start thinking mindset-wise who you can sponsor. Because that's a great question, because some people think, oh, can I sponsor my cousin or something? It's a legitimate question, but no, unfortunately, I can't sponsor your cousin unless maybe you have a company. All right, so that was the last option. But now back to your parent. All right, now to your parent, you can sponsor them even if they're in the US. However, or I'm sorry, you can file a petition for them. The problem is that if your parent is already in the US, and let's say they enter without a visa, all right, and they don't qualify for the exceptions, we call it golden ticket. So we call it golden ticket because then you don't have to leave the United States if you qualified for exception. But the general rule is that if you enter without a visa, you need a waiver to cure the failure to maintain status. Okay, so that's in general. The and also, of course, the unlawful presence. Now, if you so there's a lot of information here, a lot of legal information. You really need to contact. Of course, we recommend you call us, Ting Law Group. We're happy to help you, point you in the right direction. But there's two main things, at least with parents, that you need to know, because we want to prevent a situation where you file a petition and then come to find out you can't do the next step, right? So the next step, if your parent entered without a visa, and a lot of folks are now being able to apply it because maybe your parent, quote unquote, brought you to the US, or you came later on into the US. And now that you're a US citizen, you want to return a favor. That return a favor, not that they brought you to the US, but you want to return a favor that you want to help them, of course, that they were your parent. Anyways, how timely. This is in line with Father's Day. But, some people wonder, well, I know that I can file a petition. Can I just go all the way? Not necessarily. Because if your parent entered with a visa, the general thing, like any other person, is that they need to qualify for a waiver. This is a 601A waiver. This was created by President Obama during his tenure. 601A. This is different than the 601 form. 601A cures unlawful presence. Okay. But even if you are approved for the waiver, you still have to leave outside America, of course, at the time when your interview is scheduled. All right. Don't just leave randomly. You need to wait for the interview to be scheduled, update NVC that your waiver application has been approved, because agencies don't talk to each other. That's one key benefit of having an attorney, immigration attorney. All right. Is that we're basically like other than sharing legal advice, of course, that we're your liaison. We share updates with you. That's the way our team does it. I don't know about other law firms. That's very important to us, sharing knowledge. That's why we're here live. So, of course, continue dropping, leave your questions down below as a comment. I'll get to them soon. We have some wonderful questions. Let's see here. And I do have some follow-up questions, so please stay tuned. I'll be here for another probably 15 minutes to answer your questions. A lot of great information here. So anyway, when your parent has entered without a visa, unfortunately, even if the child is now an adult, of course, because you have to be, as a sponsor, 21 and older, children do not count as qualifying relatives for the 601A application. They do qualify for limited situations for the 601 form, but you unfortunately can't willy-nilly say, well, I don't want to use that 601A. I want to use a 601. That's not how it works. There's very specific reasons to use a particular certain form. Okay, so let's see here. So, okay, so hopefully that answers your question on that. But if your parent entered with a visa, and then you don't have to have a waiver, okay, for unlawful presence, because this is what we call, if your sponsor is a U.S. citizen adult child, then the failure to maintain status is waived. Okay, the unlawful presence is waived, and that's what we call immediate relative. Similar benefit as marrying to a U.S. citizen and being sponsored by a U.S. citizen spouse. Okay, because that's a key benefit that most people don't think about, or maybe not aware about, of course. So we're happy to share that information. By the way, folks, if you enjoy the information we're sharing with you, please click like, follow, tap the screen on TikTok, whatever you got to do, because that helps us. That means a lot to me, at least, because I can, continue going live, sharing information like this. Because otherwise you have to, for this just preliminary information. Look, I mean, most attorneys that even I talk to, I tell them to do free 15 minutes at least. They say, look, the way they've done it has worked, and they always charge 100, 150, 200. And I'm like, okay, whatever you want to do, you do you. I'll do what we do that works for us and the people that we want to help. Okay. And so don't be shy, even if you think your question, even if you don't want to hire, we want to help point you in the right direction. There's no requirement to hire us or authorize to help you if you just have one or two questions. Okay, we understand. Um, People always say I have a quick question, but we usually have a long answer for a good reason. As you can imagine, there's a lot of detail that goes into this situation. Just like I was talking about sponsoring a parent, I thought it'd be quick, but there's a long explanation. Um, let's see here. So keep dropping in your questions in the comment section, or just if you want to share your experience and others can see. Let's see here. So hopefully, Vice Chief DMD, I answered your question. Um, oh, and also, by the way, if you are interested for that free 15 minutes, we do offer that. It's not guaranteed for everyone. Of course, first of all, you have to be kind. This day and age with post-pandemic, I don't know what it is. A lot of people are becoming more rude. Just like you, I'm sure you've seen some videos about people on airplanes and things like that. That also happens with us when people call in. I don't understand. So how it works is that you give us a call, of course, and yeah, I mean, oh, Vader Sky. Yeah, I'm saying don't. Yeah, please don't be rude, because my cares team will not schedule y'all for appointment if that's the case. So please be kind. That goes a long way. Even when you talk to, for example, anyone in, I mean, honestly, any profession, right? If you want some advice especially for free, even if you're paying for it, gotta be kind. Because there's a lot of people to help. With immigration reform to talk, and they're talking about like 11 million people without status here in the United States. And of course, there's way more people that want to come into the United States illegally or illegally, I guess. So that's the other thing we're trying to share. Anyway, back to how to contact us. You can go to our website, greencardguys.com. Apparently on TikTok, I'm not supposed to share a phone number or something. But you can go to our website, greencardguys.com. Go to that. But if you're here live, you can go to you can call us 832-838-7272. I believe that's one of our phone numbers. Let me double check that, and I'll answer some questions. But anyway, you go to our website, greencardguys.com, and you go to, let me type in this number, make sure it's correct. By the way, if that number doesn't work for some reason, oh, I'm sorry, 832-838-9797. Okay, that is the phone number. Okay, that's a team member to make sure it works. So I think there have been a couple comments of people. Hey, what's up, Barbie Cardian? What's up? What's up? Yes, Teresa, we do speak. Our team does speak Spanish. Hablo español poquito for myself. All right, thanks for the question. You're pretty funny, Vader Sky. Diane, if you're a legal immigrant, no problems. Kind of depends what you mean by legal immigrant. For example, we had a client who got approved for an investor visa, and of course, I'm not sharing the name, but recently got arrested for DWI. So it depends what you mean by illegal immigrant. Sometimes even legal immigrant can get themselves in trouble, and depending on jurisdiction, the county or the city that you've been arrested, they might refer you or transfer you to ICE. Fortunately, he was not, but there's other people that are not so lucky and get transferred to ICE custody. And with DUI, DWI, technically, he's still a legal immigrant, but the immigration judges don't like that. Okay, and if you're detained, there's case law, a Supreme Court case, I think at least about 2018-ish, around that time, that yeah, they can detain you even with DWI. It used before that case, they used to release people a little bit more liberally. Well, not liberal, but it was possible. So especially if you have two DWIs or DUIs and you're detained, even with a green card, even with a non-immigrant visa, it still could be a problem. So Um, kind is key. That's right, Benjamin. I'm getting a lot more questions on TikTok, so I appreciate it. I'll get to that soon. Teresa, number is 832-838-9797. And I'm sorry, if for some reason doesn't work. Please give us go to our website, greencardguys.com. I'm not sure. Am I able to comment on TikTok? Okay, it looks like I can. Okay, cool. All right, so uh, real quick, back to the topic of the day is the Florida law. Okay, what to be aware of. This is one of those laws that are similar to Texas and Arizona from a few years ago, where they're basically saying, you know, if you get if you see an immigrant or if you know there's an immigrant in the car, you can notify police, which doesn't make sense. Why would you be in the same vehicle with someone who would report you? And then also that police can have authority to, report someone to immigration, which in Texas, at least, I was more familiar with that law from SB4 from a few years ago. That law passed, but fortunately, I haven't heard of any police or law enforcement, sheriff actually reporting people. That would be interesting. The Democrat representative, I remember, was following very closely, try to get amendment in to get the data on that, right? To see how many people are actually being referred to ICE. Um, but that didn't pass, of course, because I think it was just really for what you call for show, political show. Is it really practical? That's the thing about all these politicians these days. The laws they're creating, is it going to be practical? Is it going to help people? I don't I didn't see any problems. In Texas, a lot of sheriff, a lot of law enforcement officers went to testify in against that immigration enforcement law, SB4 back then. And politicians don't care. Okay. They don't care. Of course, it depends on the side, depends on the issue. So, anyways, I will record another video by next week to go in more detail about the Florida law and definitely what to be aware of. But this is a quick live show. I'll be on for maybe another 5-10 minutes. Let me answer some more questions. Marvelous Zone 3350. If you're still on, would you be so kind enough to explain the I-245, please? I think what you mean is 245I, but I get what you're saying. Your application was done. Okay, you're still live. Okay, thanks for posting the number 832-838-9797. Your application was done on the job applicant I-140. Okay, so great question. All right, so the thing is about 245I, if anyone's not familiar with this is what one of the golden tickets, I like to call it, and that is 245I. It's an old law that President Bill Clinton grandfathered. Okay, essentially saying that if you have a petition or a labor certification, so that may be in your situation, Marvelous 3350. If you have a labor certification from a long time ago, and that was before April 30th, 2001. Okay, as long it was filed. Now, for the petition, you can't. They say it doesn't have to be approved, but as long as it's at least it's approvable, meaning you actually was you filed that you were eligible to file the petition and get approved, then that counts. Okay. Now they say it that way because anyone could technically file something, but maybe the USCIS at that time did not reject it, so technically had a receipt notice. So they want to make sure that the relationship at that time, before April 30th, 2001, that it was legitimate relationship, family relationship, for example. Now, in terms of some other requirements, by the way, the benefit of this 245I is basically the main benefit is not leaving the United States, okay? That you stay here for the resident status. You don't have to leave at all. You don't have to file a waiver, but you do have to pay a penalty. So if any Spanish speakers are familiar with the term like multa or fiance, I was about to say fiance because there's a question on that, but fianza, yeah, un mil, $1,000 penalty. That's what that is, the 245I. I'm sure anyone these days, hey, even though it was, no one wants to pay more, but hey, if it could save you a plane ticket, you might as well pay USCIS this $1,000 if you're eligible for it. Now, you do generally have to show proof that you were in the US December, I believe it was the 20th for some reason. Usually when they have rules like that, like for example, DACA, I believe it was June 15th or June 12th. I believe it was June 15th, 2012. Getting all these dates could be possibly mixed up. It's usually you have to show proof of being in the U.S. that day, the day that the law became effective. Okay, so that's how I remember it. So 245I, you used to have to show proof that you were here. Let's see here. Yeah, December. Okay, I was one day off. December 21st, 2000. Unless your document was filed before January 15th, 1998. And we've actually had several clients in that situation. So because they have the petition or notice of a receipt or the labor certification notice filed before January 15th, 1998, we did not have to show proof that we're here in the U.S. December 21st, the year 2000. Okay. A lot of kind of quirky requirements, but I guess it could make sense. I'm just surprised a lot of people we've talked to able to show proof that you were here in the United States December 21st, 2000. Even if it's not precisely that date, the government understands. We always ask client, maybe there's something that week or that month, and file it. See, just because you may not have the precise week or day, don't let that be something that stop you from applying, because if it gets approved, you don't have to leave the United States for the visa interview. And trust me on this, we file lawsuits against the government. We call it mandamus lawsuit because of delays in cases, whether it's in the U.S. or abroad, but definitely when it's abroad. Also because you don't want to be waiting even some people don't want to wait a week, but sometimes you might have to. Okay, so it's unfortunate that just the consular officers, I don't want to blame the officers, but maybe it's just probably their systems, their workflow, or lack thereof, that they are slow to issue a visa. Now, some people get it in a couple of days, a week, but not everyone. Okay, and unfortunately, especially a lot of Russian nationals and people from the Middle East, Pakistan nationals, there's a long delay. Okay. But also for Russian nationals, as you can imagine, unfortunately, of course, the government does vet people for national security. At least I would think so. That's what they claim. So they do that for Russians as well, and also from folks in the Middle East. So that's why it takes a while. I don't know why it has to take a long time. They say, oh, wait 180 days, but that's just ridiculous. They need a better system. Because if that was the case, a little rant here, you would think they'd do that before they even schedule you for interview. Why even go through that process? Seems ridiculous, because if there's really national security concern, why even call you up for interview? Because they don't ask those questions. Of course, why would they? Because you could just lie. Someone could lie. So that's just food for thought, I guess, on my rant. Teresa, I just see your comment now, but yeah, if you didn't catch the number, it's 832-838-9797. Marvelous, you said you filed it and was approved, went through the process, and it didn't. Oh, you went through the process. It didn't get the green card. Well, Marvelous, do you know what happened? Let me know, okay? Do you know why you were denied? Did you get a denial letter? What does it say? In these kind of situations, folks, like even if you're denied, you get an RFE or notice of intent deny, whether you have a lawyer or not, we don't like to step on anyone's toes, of course. But if your lawyer hasn't been responding to you, now look, if it's been like less than a week, and especially today's technically a national holiday, federal holiday, cut them some slack here. But for us, we respond in 24 hours. Okay. We have a deep team. If I'm thinking like hockey, because the championship just went completed in hockey, NHL, and also NBA. I think like this: we have a deep bench that can help you. You might not get the legal answer you want in the moment, but someone can, take in your question and we can get another response by the legal team within another 24 hours, if not the same day again. Okay. So, anyways, hopefully that helps. Marvelous. Maybe you sent the I-140, but not the labor certification. The labor certification form back then was called the ETA 750. And for those folks that, you're like, well, shoot, I lost all those documents. What do I do? You can file a FOIA, Freedom of Information Act. Okay. That is free. You can do it on your own. But if you want to save some time, of course, we do charge a fee. I don't usually like to share fees, but to cut you chase, honestly, normally we charge 1,500 for a FOIA. Okay. But for those that follow us, subscribe, all that jazz, we do offer reduced rate in half, 750 for the FOIA, in case you don't have those documents. Now you can do it on your own, but at USCIS or whatever agency you're looking to get those documents from, generally take a long time unless you know exactly what you're looking for, because I do have a question on there, what documents are you looking for? So generally speaking, if you're going to just say my entire immigration file, for some reason, it's going to take longer. I don't know why it does that, but or why the government takes a long time when you're asking the whole file, because I don't know how that works internally. You just type in a name, you would think something pops up. Maybe there's an example, bots should be able to help with that. Kind of crazy, but another example. All right, Teresa, let's see. Let me see your actual question. I know I've seen some questions about quote. It's difficult to share all the numbers because it depends on everyone's situations in general, but we offer 3 different plans: Max, Pro, and Light. And they have 3 different ones because in general, people want to know how soon to file. So, of course, if you're a little bit more anxious, or maybe you're not anxious, but you're just like, I know what to do. I know I'm going to follow your Ting Law Group's proven checklist. I want to file my case in 30 days. We can do that. That's the max plan. All right. Also includes preparing you for an interview. All plans are prepare you for an interview. Even though right now 2023 trend is to get marriage cases approved without an interview, so the interviews are waived. It's the middle of 2023. We don't know what's going to happen in 2024, or even if President Biden is not in office anymore. We just have to assume, unfortunately, someone else could be in office. All right, whether you like him in office or not, or even if he's stumbling around or not, we don't know if he's going to be in office next year. So things can change. So our plans have not changed. We kept the same thing. And Max Plan also includes to be there to represent you at the interview. Okay. Not everyone requires it, but every time I've talked to colleagues, friends about this situation, we're like, oh, client didn't want us at the interview, but then something happened. It was a clean case, but something happened. Officer gave them a hard time, and they got separated in different rooms. So that's not a good thing. All right. All right, Teresa, sorry about that. I'll get to your question. Oh yeah, pro plan will file your case in 60 days and light plan in 90 days. Okay. And some people do ask, like, well, if let's say I pick pro in 60 days, but I get you everything in 45 days, will you literally wait to 6 days? No, we're gonna need a couple days to review it, a couple weekdays to make sure conduct our due diligence. But ultimately, you might want to we don't hold it up. Okay, we file it anyway. Oh, cool. I swipe the screen and it shows the questions a lot larger. That's good. Your aunt, okay, Teresa, your aunt is in her 80s. Mother is a U.S. citizen, but now deceased. She never applied. Let's see. My condolences, of course. Oh, she never applied. Yeah. And you want your mom would have needed to file that petition I-130 at least, okay? So sorry to hear that. Yeah, can your dad as a U.S. apply for her as a sibling-in-law? No, unfortunately, no. Doesn't look like you're on, but sorry, I answered your question a little bit late. If I see you get back on, I'll answer the question again. Let's see here. Ashti Hamka. Okay, Ashti. Let's see what's going on here. Ooh, your K1 visa, you got put in 221G for 4 months. What should you do? Yeah, you might want to consider a lawsuit. File a lawsuit against the Department of State and your embassy where you're at. Um, I don't want to assume, but we have a lot more clients from Pakistan, for example, and of course, a couple other countries are top ones that get delayed significantly. So you might be in that situation where you might want to file a lawsuit. Okay, consider that. You can go to our website greencardguys.com and download the free guide down at the bottom. Click on the one that says case delay or sue for legal status, I believe. All right, hopefully it helps. Let's see. All right. Back to Marvelous. You said, get to YouTube in a second. I see your question. Marvelous, you said you filed it. It was approved, went through the process, but you didn't get the green card. Okay. Well, that's a little strange. How long has it been? Sounds like it's recent. It does. I mean, we've been fortunate. Our case experience is usually, in terms of getting the green card after approval, is usually like 2 to 3 weeks. But there are some people, unfortunately, it takes a little longer. Um, in that situation, you want to submit an inquiry. See if you can do that online, uscs.gov. Click on tools and resources. Okay, hopefully that helps. Well, appreciate the question anyway, though, about 245I, but you didn't need that explanation since you got approved. Oh, it's been a long time. Yeah, submit an inquiry. If you have already, then let's talk. Give us a call. But hopefully you don't need us. Okay, Marvelous. But I would submit inquiry. And I'm assuming you probably did that already as well. So if that's the case, then the next step is called what we call the Ombudsman Office. We lately have not needed to use their office, fortunately, but Ombudsman, let me see if I can type that in. If you just type in US CIS Ombudsman, just Google that. Okay. I'm surprised I was able to type all those letters. Okay. Google search that. That's what I call the worst case scenario. Your situation, Marvelous, you don't need a suit because they already got approved, right? But it would have to say notice of approval, which I'm sure you saw. So, and you're in the US, so you don't have to pay an extra fee of the 220. That's for people who are abroad. Okay, go through consular processing. Okay, so I'm trying to see if there's other questions because I know the other comment. Okay, YouTube. Sorry about that. Claire, no news, but I'll check again with my team. We'll check that. Okay, but I haven't heard it on the circuit or basically our message board. So, but I'll check that. Okay, Claire, we'll get you an update tomorrow if there is, whether there's an update or not. Okay, Malik. No, I mean I've been saying I'll record a video about it, but I'm sorry, nothing yet, nothing substantive, unfortunately, about the Dreamers reform proposal. It's just a lot of chatter, okay, and I really prefer not to. I really prefer not to record a video only on chatter, to be honest, and especially if it's really like 5 co-sponsors, like something that's going to get some movement. There's so many immigration bills, pro or against immigration, or just any proposal in general. It's not going to get any movement traction if there's not many co-sponsors. So I don't want to mislead anyone. But Malik, you have a follow-up question to ask. How successful would it be for a file hardship case for a person nearly in 30s through green card citizen parent who has some medical issues? So in general, we're able we've been very successful, knock on wood, okay? But we've been very successful. This is a great question because some people don't think about this, that maybe you have been approved for the petition, and we've had some people call and say, well, I'm just waiting for a visa bulletin. Well, then we tell them, like, look, it's actually great that you're still waiting on visa bulletin because you have the time to get your waiver approved. And most people say, I didn't know that I needed a waiver. So it's good Malik, good that you know this. You do need to file the waiver, okay? 601A, it seems like, based on what you're sharing so far. But of course, give us a call or call an immigration attorney to verify if that is a particular waiver you need. But typically that is for unlawful presence, 601A. And yes, if there are some medical issues, that can be helpful. You essentially just stating to USCIS in your letter or your parents' letter, really do both, is not enough. You have to explain how you're helping them. How is their hardship of like causing you to help? Okay, and it's not meaning that you have to literally help with every single thing. Maybe you have hired help for other things. But maybe you could talk about, if you do have hired help, maybe you pay for the hired help, maybe you help coordinate it. Okay, there's a lot of things involved. Okay, so hopefully that helps. But yeah, but for those other folks who maybe have parents who are resident holders or U.S. citizens who could be your qualifying relative for a waiver application, that doesn't require medical hardship. Okay, a lot of it can be speculation. I know it's kind of weird. If you have proof of it that's existing now, that's great, but it can be speculation for the future. So come to think of it, I need to record some videos to help you all out as pointers on the waivers itself. Okay, let's see, because I'm basically sharing it right now. So hopefully, Malik, that helps. Kelvin, we do removal? Some cases, not all of them. We're very particular on removal cases, as you can imagine, just because we have to be across the country, depending where you live. Most courts these days don't always allow what do you call video conference, so you still have to fly out. And but maybe, Kelvin, you're in a situation where it could be qualified for PD, prosecutorial discretion. Okay, maybe that's possible. But to make it even stronger for it to be possible, you have to have some kind of eligibility, the petition filed with USCIS. Now, time you call us, you might not have petition filed. That's okay, but that's our goal, to help file that for you if you haven't. Hey, Lloyd Russell Holmes, nice to see you. I don't know, for some reason I thought about you though yesterday. We need to chat soon. Hope you're doing well. Zamali Z, any successful cases with PD memo? Yes, we have successful cases with PD about PD in general. Now, PD memo specifically about cases that are people that are have been order removed. That's still on hold right now, as far as I've seen it and talked with my colleagues. That's on hold if you have a removal order. Now, unless you're in a specific situation where maybe your case just got recently order removed because you didn't know about your court hearing. I had someone call from Pennsylvania, I believe, Philly, the other week, and they didn't know about it. They moved. I believe they updated it, okay, their address with the court. So you want to get that reopened as soon as possible and dismissed at the same time. That person, I believe, married to you, said, yeah, they had a kid too. The husband was taking care of the kid. They were on the video call, so I remember now. Yeah, so hopefully that helps. Yeah, we do have other successful cases. If people are just asking, well, I got a court case, can I just get it dismissed, and I don't have any eligibility to file a petition, unfortunately, it's going to be very, very difficult. Okay, very difficult. So those kind of cases we wouldn't accept if that was the situation. But we're happy to chat with you, see if there is something that you qualify for. All right. And by the way, hot tip here before I hop off in less than 5 minutes is that you might think, if you don't have a family relationship where that person could sponsor you, or maybe you do, but that person doesn't want to sponsor you. I've actually heard that. then you want to think about a company to sponsor you, okay? Because by now you probably have some kind of resume, hopefully, or work experience, if anything. But you want to, of course, prepare your resume. And yes, it is possible, even if you don't have non-immigrant visa right now, it does get complicated. It is complex legal situation, but let's chat about it, okay? Not everyone qualifies, but if you're eligible for waiver, that certainly can help. Now, if you file for asylum and have asylum pending, that could help, and you filed it timely. All right. Not every one situation is going to be smooth. All right. Um, some are going to be less complex. Some are going to be more complex. Let's see here. Malik, your question on YouTube, and I'll get back to TikTok. Would asylum be the first step in cancellation removal? Then does a case move to court where they make a decision based on hardship to the green card citizen parent? Would it be safe? Okay, I think what you're trying to say, let me make sure here. Okay, first, asylum is a separate application. All right, then cancellation removal. So cancellation removal is there's many requirements for everything, right? Whatever you're applying for, it's not just one thing. So on these live shows, I just go quick, right? But you do need to speak with an attorney one-on-one to make sure that you're eligible for all of it. What we call, especially for court-related cases, that you're prima facie eligible. Okay, that's a key phrase that we use. All right, so your question, Malik. No, asylum is not necessarily the first step. It's a separate application, 589 application. You can actually do it online, but if you're in court, you got to file it, mail it in, okay, to the asylum office and to the court, okay, and also actually the government attorney, Department of Homeland Security. But if you're eligible for, and you might not be eligible for asylum if you're already been in the U.S. for more than a year, but you could be eligible for withholding and removal. But again, that's a separate application than cancellation removal, which is 42B form or 42A if you're a resident. But yeah, cancellation removal for non-residents, currently basically someone with no status right now, the first requirement we always ask is, have you been in the U.S. for 10 years before you receive the notice to appear document, or if certain crimes occurred that cuts off the time period, okay, the counting of the time. Oh, you asked, then the case moves to court where they make a decision based. I don't know your situation, Malik. Sounds like you're not in court, actually, like you don't have a court hearing. If you don't have a court hearing, you don't have to worry. Oh, I think I see what you're saying about asylum first. If you file for asylum and you were denied by USCIS, yes, your case does get referred to immigration court. And then, yeah, possibly you could file for cancellation removal at that time if you're found to be eligible, prima facie eligible. Oh, Malik, you haven't filed anything. Yeah, if you're if you still have time that you're in the U.S., like you haven't reached 1 year and you're in the U.S. and you think you have a case for asylum, I wouldn't just basically, if you don't have a fear of your country or where your country of nationality, then I would not file for asylum because they do penalize people who file a fraudulent case, not asylum case. Not to say you would, but I'm sharing this for everyone because I do take that seriously if somehow they find out. Okay. But if you believe you have a claim of fear from your country of nationality, then you want to file that definitely before the 1 year mark of your last entry in the U.S. It's very, very important. Okay. Because then you can get a work permit, among other things. Okay. But if you don't file in time, then you don't get opportunity to file for work permit. Okay, so I got a lot of strange comments, unfortunately, on TikTok. Seems I get more strange comments on TikTok than any other platform. I don't know what it is, but by the way, if you're still on, I appreciate it. Please click the hearts, likes, and tap the screen if you're on TikTok. It really helps the algorithm, however it does it. I have no idea, but let's see. Gimpy Grego, happy to answer your question. What is my biggest lesson learned in life thus far? My goodness, that's a hefty question. I have a lot. I have a lot of lessons learned, but I can say at least. Can I say two things? Just being grateful and being considerate. Yeah, that's just a lesson learned. I don't. There's so many scenarios that I've learned that lesson. Okay, hopefully that helps. Jenna, is there a reason the processing time has increased dramatically? USCIS will say that they don't have as many people working. They're always going to say that, and they'll blame the government. They say Congress doesn't pay us. All right, they're always going to say that, but it's y'all that are applicants, petitioners, beneficiaries. Y'all are funding USCIS. Okay, so their excuse about not having enough employees, it's 2023. I mean, there's technology that can help them process faster. That's how we are able to get to respond to y'all faster in less than 24 hours, usually. Okay, not every time, but usually. Can't promise that. But yeah, that's the main reason. And also, I think the bureaucracy, essentially, when there's so many levels, the hierarchy, so many levels of leadership, things can slow down, right? So that's very unfortunate. Redneck, I'm not sure how I can help you, so I'm not sure why your questions. Anyways, okay. So again, if you are new to the channel, we do offer free 15 minutes. Um, you can give us a call or go to our website, greencardguys.com. Happy to help you. All right. Ashti, if you didn't hear this, for those folks that are case delayed, the what we call unreasonable time delay, we do file lawsuits. Yes, we do help with that. All right, I think I covered it. All right, all right. I appreciate it so much. I wish y'all the best, and y'all have a wonderful Monday. Happy Juneteenth, and I'll see you tomorrow. All right, take care now. Bye bye.